Okay, is it working? Alright, I'm here. Is anybody else there? Just making noise. No, I need this here. How do we arrange this? I need another window. I can't hear. Knock, knock. How do I... No audio. I'd like to hear all. I can't. Why can't I type? Is there a way to detach that? I can't hear a courtroom. Can you turn on the audio? They're not gonna do shit. I'll be right back.
Mr. Greenberg, do you think he can hear me now? Mr.
Yes.
Greenberg, can you hear us now?
Yes, thank you.
Well, I don't know that we can hear you.
Okay,
Try
let's
again.
hold on. Let me figure it out. Audio. Learn how. Okay. Zoom. Allow. Block. All right. Where was it? Zoom meeting. Hold on. What is it? Oh. What the fuck?
Mr. Greenberg, would you try speaking one more time just to make sure?
Yeah, I'm
Just,
trying to speak, but I guess you're not hearing me.
we cannot hear you,
Okay.
so there's something on your end, I think, that needs to be unmuted.
Yeah, I'm working on it. Stop. Oh my god. Alright, let's try it. Let me try to rejoin. Testing. 1, 2, 3. Same as Joined by
Sorry, ladies and gentlemen, for the delay. Hopefully this will
Yeah, I'm working on it.
get resolved.
I hear that. What is the microphone? Alright, where? Hopefully. Where is... Alright, I'm gonna have to disconnect. Alright. I'll connect via Zoom. That's not what I want. Sent. Hello? Yeah, is it working? Are we there? Is it working? Do we have audio? Unmute. Okay, is it working? Hello? Okay, is it working now? Hello? Any audio? Okay, is it working? I can't hear. Now I,
Yes, yes.
now I hear you.
Can you? All right, great. All right. So you can hear just fine now, is that correct?
Yeah, it's a little loud. Let me turn it down.
Okay. All right. All right. For the record, we are here in case number 2302241, Robertson and others, plaintiff versus Daniel Greenberg and others, and then Mr. Greenberg's third-party complaint against John T. Meyer and others. We are here today for certain motions that have been filed. Mr. Greenberg, as I think I explained during our last hearing, when other people are talking, you will be temporarily muted because we get feedback otherwise. But as soon as they finish, we'll give you an opportunity to reply to whatever motions are going to be heard. All right.
Okay,
You have a question.
yeah, I have a problem with that in that doesn't really give me the ability to object and keep things off the record that shouldn't make it to the record.
Well, I'll give you an opportunity to object after they have
Well, no,
finished.
that's not how court works.
Mr. Weaver, just listen for a second. That's the way we're going to do it. If you object and I grant your objection, I will not consider any evidence that comes in that should not be there.
Okay,
So
because
I will
we had a
strike
problem
you.
the last time when someone made some outlandish claims that can't be substantiated by law.
Well, Mr. Greenberg, maybe I should explain it this way, and then we'll go on. What attorneys say is not evidence. What you say, unless you are under oath, is not evidence. Those are simply arguments for the
Okay.
court to consider. And so if you can point out anything that you think or object to whatever you think is irrelevant or improper or untrue, and I will take that under consideration.
Okay,
Okay,
so
but that's the way we're gonna do it.
okay, so maybe it's best we decide which motions are going to be heard in what order.
I'm getting ready to go through that right now. So just let me ask for your benefit and mine, for the attorneys who are here to present motions today, to please identify yourself and your client and what motion you plan to address today. Sir, we'll take yours first.
Morning, I'm Jonathan Cole. I'm here for Judge Joe Binkley, and I have a motion to render his dismissal of final judgment.
Okay. Mr. Cole representing Judge Binkley. Did you hear that, Mr. Greenberg?
Yes, I wrote it down.
All right.
Is there not a
All right, yes,
list?
No, sir, not a list right now. Go ahead.
Lynn Gillespie with Robertson and Schustein, we're the plaintiff and the interpleader.
All right. And that is Ms. Gillespie is representing the original plaintiff in this case,
Correct.
in the original cause of action. All right. Yes, sir.
Your Honor, my name is Timothy Palmer with Ogletree Defense. I'm here on behalf of Dean Alberto Gonzalez and Dean Chris Guthrie. We have two pending motions for sanctions under Rule 11.
All right. All right. Yes, sir.
John Maher for Carly Gifford.
Maher.
Yeah.
I got it right this time. All right.
For Carly Gifford, that's our motion to dismiss his third-party complaint against Carly Gifford.
Okay. All right. Anyone else?
Your Honor, my name is Chris Davis, here on behalf of.
I'm sorry, sir. I didn't catch your
I'm
last
so
name.
sorry, my name is Chris Davis. I'm here on behalf of Dr. Lindo. We're just here present for the case proceedings.
Okay.
Thank you.
Motion pending at this point, do you?
I believe you've already submitted one, Your Honor.
Yes, sir.
I
I think I
didn't.
ruled on it already.
I
All
di-
right, Mr. Greenberg.
Yeah,
you have a question?
Yes, I didn't catch the last gentleman, what his purpose or who he is.
His name is Mr. Davis. He is here representing Dr. Galindo, but he does not have a motion. He's just here to observe the proceedings today.
Oh,
So
good,
there's
a
no
court
motion.
watcher.
Yeah. Now, are there any motions that you have filed prior to January the 31st that you wish to argue today?
Oh, yes, the list is exhaustive. Would you like to go through it? I gotta fix this delay.
Well, let's go ahead. We're going to try to deal with what we have pending today, and it would be helpful to know what you intend to argue today. I know you have several motions for default that you have filed.
Okay, well, let me pull up. This is why I requested what any other hearing would have in regards to a docket. You go to a hearing, and there's a docket of the motions that are scheduled, and that's non-existent. So
Well, if
I
you'll
don't.
just tell me what motions you plan to argue today. sir.
Well, let's go through the list. I guess this could take an hour. This was supposed to be done by the court, not me. When I schedule it, it's supposed to make it to the motion docket for the hearing.
Well, I'll tell you what, let's do then. Let's take up the motions we know, and then we'll get ready, then we'll come back and.
No, that usually never works out into my favor.
Well, that's the
So,
way, that's the way we're going to do it.
no,
today.
that's not the way justice
Mr.
works.
Greenberg, I've ruled, that's enough. Let's take up the first motion. Mr. Cole.
Oh, no. I already object. See, okay,
Mr.
so,
Greenberg.
let's,
Mr. Greenberg, we're going to hear Mr. Cole.
No.
Go ahead, Mr. Cole.
because
Morning, Your Honor.
hearing
Jonathan
my
Cole, as I
order.
introduced before, I represent Judge Joe Binkley. This is a relatively simple matter. Judge Binkley was one of the parties that moved to dismiss when the court had its previous hearing back in the late fall.
Yeah.
And the court entered an order, as you know, on December 15th, dismissing Judge Binkley along with a number of other dismissals at the time. And so Judge Binkley is respectfully moving under Rule 54 to render that a final judgment so that his case can be finally determined and can get some resolution of it. So I'm happy to address more than that, Your Honor, but it's relatively simple.
Fairly simple.
Yes, Your Honor.
All right. We can unmute him for just a moment. All right, Mr. Greenberg, did you understand what Mr. Cole's motion is? He wants my order dismissing Judge Brinkley to be deemed a final order pursuant to Rule 54. Do you wish to respond?
Yes, I think it's improper for the court to issue any final orders given that there are motions pending that would negate what is asserted in that order. Right?
Okay. Anything further?
So what I'd like to hear is the sua sponte appointment, judicial notice of facts and law. That's going to be most important that that matter be heard first, because not doing so is going to compromise any further motions that are heard subsequently. And if you hear them previous to that, you're going to have to go back and redo them, and that's not appropriate. And this was filed in a timely manner to have this done in this manner.
Okay. Well, Mr. Greenberg, I'm going to go ahead and rule on this motion. If for some reason I should deem my ruling to be in error, I will certainly file an amended order. But I'm going to go ahead and rule at this point in time. Motion granted.
Okay.
Prepare me an order.
I will, Your Honor. Thank you.
All right, next motion. Ms. Gillespie, are you up next?
So why am my motions not being heard?
You're going to be heard.
No. But I need mine heard first, so that anything that they bring forward can be refuted by the fact that we already resolved what it is that they're claiming did not occur.
Mr. Greenberg, I don't think that's going to be proper in.
That would indicate some sort of bias.
Mr. Greenberg, we're going to hear the motions in the order that I have stated. So I'm going to take up Ms. Gillespie's.
There was no.
Ms. Gillespie.
Your Honor, Lane Gillespie for Robertson and Schneid. We had filed this petition in order to deposit funds into the registry, and we would just appreciate an order that would allow us to do so and award fees and costs associated with the filing.
All right. Mr. Greenberg?
Yes.
This is the original plaintiff in this matter,
Right.
who filed the interpleader action seeking to pay funds into the court, the excess funds from a foreclosure sale. She is seeking to go ahead and be able to allow her client to pay those funds into court and for the fees and costs associated therewith.
Yeah.
Do you have a response to that motion?
Yeah, I object because there are issues surrounding their participation in these hearings, and once the money's given to the court, I'm not sure that they've done due diligence to ensure that the rightful party actually receives the funds. So,
Well, Mr. Greenberg, I'm not allowed to give you legal advice, Mr. Greenberg, but the monies will be held by the court.
but I don't trust the court. You understand that, right?
Sir, Mr. Greenberg, please let me finish. Everyone who perhaps has an interest in in these funds, including you, will be given an opportunity to come in and prove their right to those funds. So they'll be held right now they're being held by the plaintiff.
Right, and I prefer
Now
that they
they'll be
do.
held by the court. Well, I'm going to grant their motion. They're going to be paid into the court, and then we will take the appropriate step of a hearing and allow those people who may have an interest to come in and prove their right to those funds. So draw your order, Ms. Gillespie, submit it, and I will sign it.
Okay.
Thank you, Your Honor.
So it's
All right.
possible that they've witnessed things that would, yeah.
All right, let's see. Mr. Palmer, on behalf of the deans?
Yes.
All right.
May it please the court, Tim Palmer on behalf of Dean Gonzalez and Dean Guthrie. We have before your honor two motions for sanctions under Rule 11.
Yes.
Based upon the complete lack of factual or legal basis asserted against my clients in the course of this litigation. The court heard our motions to dismiss last fall, granted those, finding, as we argued then, that there was simply no factual basis for allegations against Dean Gonzalez or Dean Guthrie. As a matter of fact, in the course of that hearing, Your Honor may recall that you asked Mr. Greenberg specifically why my clients had been sued. And at that time, his response was simply that he felt they should have filed a bar charge against the attorneys and judges he's made defendants in this case. There is no factual basis for such an assertion. There's certainly no legal cause of action based upon such an assertion. And we contacted Mr. Greenberg appropriately. We requested that this action be timely dismissed so that my clients would not incur the time, cost, and expense of defending themselves in litigation. This sort of abuse of the litigation process is exactly what Rule 11 is for. I'll tell you, Your Honor, in 35 years of practicing law, this is only the second such motion I've ever had to file. But it's entirely appropriate here, and we request that sanctions be entered appropriately against Mr. Greenberg. If the court grants our motion, we would certainly submit an affidavit showing our costs and expenses and request an award against Mr. Greenberg and assert it against whatever interpleader funds he may ultimately be entitled to in this case.
Thank you. All right, Mr. Greenberg, would you like to respond to the motion?
Yeah, I object on principle that they are aware of the child trafficking in these courts and have failed to report it to the proper entities. And if they're going to derive funds off that illegal enterprise of racketeering, that is problematic for them potentially in the future.
All right, anything further?
No, you can take it out of my my judgment against all the others.
All right. Mr. Palmer, I certainly think your motion is well taken in this matter. I will say for the record that I do find the third-party complaints filed by Mr. Greenberg to have been frivolous, without merit. And those are exactly the type of filings that this rule is intended to hopefully dissuade people from filing. So if you will submit your order with your affidavit, I will be considerate. Thank you.
Thank you, Your Honor.
All right. And I'll try again. Mr. Maher, did I get it right that time?
Yes, you did.
Close enough?
Thank you, Your Honor. I'm here for Mrs. Carla Gifford this morning, and this is, again, a motion on the third-party complaint, motion to dismiss or failure to state a claim. I rely upon my brief. I did lay out all the legal and factual basis that we had for that claim, but
There was no brief.
just in the way of highlighting it, it appears that he's doing a third-party cross-complaint based upon fraud. Of course, the law requires specific facts and finding to be placed in the complaint,
Right.
indicating the fraud. It appears that Mr. Greenberg's only argument, which isn't clearly stated in what he calls third-party complaint, is that there's a void order from California that's been attempted to be registered here in the state of Tennessee, and from that flows all of his claims. Again, this court has no court here other than there is a court ruling out of Williamson County where they did enforce that register and enforce for child support purposes, that order from California. Mr. Greenberg did appeal that. The appeal was dismissed. And so that order stands domesticating in the state of Tennessee. That's one of the
Incorrect.
allegations he makes in his complaint, is that the judge in Williamson County violated the law by doing that. And apparently, I haven't seen a lawsuit yet against the Court of Appeals for denying his appeal, but essentially that's what he's saying, is that it's void, and all of his civil racketeering, which I could not find a civil racketeering tort. It doesn't say whether he's federal, Tennessee law. Again, he doesn't require to state in his pleadings. He has to identify the statute specifically that he's relying upon, and the facts that support the violation of that statute does not do that. It just simply says a violation. Human trafficking, don't know that that's a cognizable tort. Couldn't find any tort that exists with regard to that. Again, no factual allegations regarding that. I'm assuming somehow stemming from the void judgment, which the Williamson County and the Tennessee Court of Appeals already upheld. Then he's got the real estate fraud, wire fraud, and interstate commerce fraud. Again, could not find any cognizable tort in the state of Tennessee, and he doesn't identify any factual basis for that, or specifically what that tort is. Again, if it's in the realm of fraud, he has to state specific facts, and there are no specific facts pled with regard to Mrs. Gifford, that she committed some common law conspiracy, human trafficking, any of these things. All those, I think, are based on what he says is a void California judgment, which, of course, my client did not enter. She was not the judge. She didn't enter the order.
But
She
she
was a participant in
benefited
that.
from
She's a
it,
party
so
in it.
she participated in the fraud.
And I think his ultimate issue here is that's void. He wants some court somewhere to find it's void. And so we continue down that road, but certainly not a complaint, any cognizable complaint, third-party complaint against my client for trying to register a foreign decree.
Thank you.
Thank you.
Mr. Greenberg, your response, please.
Yes, I have many issues with this. Had
Just a
we
moment,
heard,
Mr. Greenberg. Just a moment, Mr. Greenberg. I think we've got to unmute
Okay.
Okay, now I think we can hear you.
yeah, I had many objections to the claims or whatever statements he made. First and foremost, it's inappropriate to have his motion to dismiss prior to the sua sponte appointment judicial notice. That would establish the facts and the law, which he has negated with some sort of side deal with you behind closed doors.
Mr. Greenberg, you are getting dangerously close to having yourself found in contempt of court if you continue to make those sorts of allegations. So I suggest you stick to the facts in this matter.
Okay,
Just
that's
forewarning.
possible, right? Okay, so regarding his motion to dismiss, so I could actually state a claim, and as long as you say that I didn't state a claim, no claim was stated, but a claim was actually stated. So we'll go through my motion to refute the motion to dismiss, and
No, sir, I'm just letting you respond to his motion to dismiss Ms. Gifford from this, from the, your third-party complaint. So is there anything else you want to tell me as to why I should not grant that motion? And the gist of the motion is that you did not state a claim on which relief can be granted in this matter.
okay, yes, that's patently false.
Okay?
And I stated facts. See, I was.
What facts in your complaint would give me the right to grant relief against Ms. Gifford? And I'm talking about facts,
Right.
not legal conclusions or conclusory statements of any kind, just facts.
Right.
What do you state against Ms. Gifford? I'll give you an opportunity to tell me right now.
Miss Gifford engaged in fraudulent conduct in procuring the claim to the property, including but not limited to filing false documents with the court. That's a fact.
In California.
In California and in Tennessee. Okay?
And where in your third-party complaint do I find those allegations? Because I don't remember seeing those in there.
Okay.
I
Would you like to go to page 10 of the plaintiff complaint?
Okay, go right ahead.
And E, allegation. Number 1. Greenberg denies cross-defendant's complaint and asserts he is entitled to the full value. Greenberg, number 2. Greenberg alleges that cross and third-party defendants have engaged in fraudulent conduct in procuring their claim to the property, including but not limited to filing false documents with the court. That's a fact. Okay, that's an alleged fact. I can show you those documents, and that would be constitute fraud, which is a tort. If we can't agree that.
And all of this occurred in California.
No. That some of it did, but he just confessed to going down to Williamson County and filing those false documents so that she could benefit from the fraud. Is that not true? I mean, we were both here.
Right, continue, Mr. Greenberg, with your pointing out the facts.
Greenberg further alleges, this is still in the complaint, right? Are you not going to open it up to validate this, or are you just?
I've got it, Mr. Greenberg. I've got your complaint, so I've got it on my desk. So you just go right ahead.
So then he states another fact, or alleges another fact. Greenberg further alleges that cross and third-party defendants have conspired to deprive him under their color of law by conspiring to falsely claim an interest in the property and to interfere with Greenberg's lawful state and federal rights. Greenberg further alleges cross and third-party defendants have engaged in civil racketeering. I can provide you with evidence at trial after a short discovery period where that fact can be proven. If I can prove that fact, that is a tort of racketeering and fraud. That fraud has caused emotional abuse, financial abuse, reputation has been slandered, the clouding of my titles to my properties has been clouded. So we'll continue. All of this is a claim, but you've already said that it wasn't a claim, which was my original problem, in that a claim could exist and you just say it doesn't exist. All right, so then Greenberg in number 4 asserts that the cross and third-party defendants' conduct was intentional, malicious, and designed to do harm. That's the intentional infliction, that's the word, of emotional distress. See, it's intentional, it was malicious, and designed to cause harm. So I can bring you, after discovery or during discovery, documents that show precisely that. That's a claim. So I suffered a tort. And so in 5, it says, Greenberg has a direct and proximate result of these actions suffered damages, including but not limited to emotional distress, loss of autonomy, and financial harm. The court can grant relief for those causes of action alone. These are valid claims for which relief can be granted. This court must act with an integrity and functional competency of the English language and dismiss Gifford's motion. Not doing so is deceitful and constitutes additional law fraud or additional fraud upon the court under the color of law. Real estate fraud is a civil tort. An intentional deception or misrepresentation made by a person with knowledge that the deception could result in some unauthorized benefit to himself or another person. It includes any act that constitutes fraud under applicable or federal or state law. So I have alleged that that's what's occurred, that's a fact. I can get discovery that will demonstrate that at a trial. In my claims for relief section, I intermix additional claims and how relief can be granted. Declaratory relief that Greenberg is the rightful owner of the property in question, and cross defendants violated Mr. Greenberg's and children's civil rights as specified. Injunctive relief, enjoining plaintiffs from interfering with Greenberg's lawful rights and interests in the property. These are all reliefs that can be given by this court if those claims above are acknowledged and proven at trial in front of a jury. We've gone the whole circle, but somehow in previous iterations of this exercise, we have failed, willingly or maliciously is unclear, to actually acknowledge that. Compensatory damages in the amount of the $300,000 in question, as well as any damages, additional damages or fees caused by the client. Now, punitive damages in the amount of $787 billion.
Sorry, just a moment. What I had originally asked you was to set forth the facts that
Right.
on which that would give rise to a claim against Ms. Gifford. You're telling me about the damages that you are asking for, and that's not really what I need to hear. I think you've gone through what you think are the facts that you alleged. Is that correct?
No, there are additional facts.
Are they in your complaint?
Yes, they are.
Are they going to your complaint? Okay.
Yes, the first and foremost is the fact that the sua sponte appointment of the guardian ad litem to Mr. Greenberg caused the intentional emotional distress or infliction of emotional distress, whatever. All those items, that's a fact.
All right. Anything else?
Yes, the filing of the documents in Williamson County was additional torts. She, like I said, the false documents, fraudulent documents that she took down there to have certified, or what is it? domesticated in an order that was still on appeal. I mean, these are all facts that can be discovered, and to deny me the opportunity to provide that those is not there's more. The defendants, I also stated, defendants conspired to enforce a void judgment, which clearly violates the established due process rights and caused injury. There's no general dispute of the facts that the sua sponte appointment of the guardian led to this, gave rise to these claims for which relief can be granted, in addition to the other fraud that she participated in with the Department of Human or whatever, DHS, DCS in Williamson County. I mean, these are all facts that further discovery will prove that my claims for fraud, trafficking, all these other things that were in the complaint would give rise to relief that I asked for. I'm missing something. So I sufficiently pled or alleged 1983 conspiracy claim that Miss Gifford is a beneficiary of. And if I'm allowed to present the evidence, there is relief for that tort. Her agreement to proceed with all these actions was or has been an attempt to violate my civil rights, meaning that's a tort for which relief can be provided. Further conspiracy. Private parties who corruptly conspire with the judge in connection as such, acting under the court of law with the meaning, are to be held liable. That's obvious. Also included in the complaint is the exhibit Williamson County UISFA Memorandum and Order, which has the hearing that was held in Williamson County domesticating the fraudulent order, in which I tried to attack that order but was denied the ability to do that. And so again, she, as well as all the others, have tried to deprive me of my civil rights. That's a claim, and she can be held responsible for some or all of that, as well as the other third parties. It's worth noting that also Judge Robinson attempted with conspiring with her current counsel, John Mayer, her previous counsel, what's her name?
Where is that in your complaint? Where is that fact alleged?
I'll have to do a search.
All right. So,
There's much more. I mean, I really only need one.
no, and I can certainly read your complaint.
Well,
I
no,
just
but
want
that's the
to-
problem is that you say you read it, but then you just.
Mr. Greenberg, not speaking, please. All right. I have read your complaint many times. On every one of these motions, I've gone back through and read it very carefully and listened to what you've had to say about this. So I'm giving you quite a bit of time to point out those facts in your complaint. So now I'm going to let Mr. Meyer, if he wants to address any of these, he has a right to reply. So we're going to let him speak now. And Mr. Meyer, if you would like to, any rebuttal of.
Yeah, just briefly, Your Honor. I think that, again, it's Mr. Greenberg's claims all stem from an allegation, which is not in the complaint, that there was a false document filed somewhere, somehow. And this false document, he says, and he admits that he attempted to, that this false document was filed by the Department of Children's Services or Human Services to enforce a child support order from another state, and that was a false document, that judgment. But that court has already determined it wasn't a false document in the Court of Appeals, and he admits that he challenged it in there. So that's not a fact. It's like saying, coming to the court and saying, well.
I object to this nonsense.
Just
I can't hear. I can't hear. What did you do? What's going on? I can't hear. Hello? I can't hear. What did you do?
Can you hear now?
Yeah, I finally, what happened there? That can't happen again. You guys are having private conversations.
Mr. Greenberg, we didn't say anything. We stopped when you said you couldn't hear. So nothing was said. All right.
I saw lips moving.
We were just simply trying to see if we could get the system fixed. Now, let him finish, okay? Go ahead, Mr.
So again, Your Honor, his entire action stems from his allegation that the order of California was a false document. I think the court's already determined in the prior motions to dismiss that that was not a cognizable action. And that's the entire basis for everything.
That's not true. Object.
Let him finish.
And so, again, Your Honor, his allegations just do not have any basis. In fact, he doesn't even delineate those facts in his complaint.
That's what discovery is for.
All right.
So I have issues.
I think I've heard enough, Mr. Greenberg. I will put down a written order, Mr. Meyer, as I did on the previous motions, because I think probably it will end up somehow being looked at by the Court of Appeals. And it's important that they know my reasoning on what I do. So I will.
You're just going to make me appeal because you won't acknowledge that claims were stated for which.
Mr. Greenberg, I am going to put down an order on his motion, and you can do with it whatever you wish. All right. Anything else, ladies and gentlemen, from the attorneys that are here in the courtroom that I need to address? Mr. Meyer, don't you have a motion for sanctions or something in this matter? I didn't know if you were planning on hearing that today or not. I guess it depends on what I do with this in some ways, but.
Yes, Your Honor, and we did have a prior motion for sanctions. We argued at the last hearing.
That's correct.
And that there would be,
File it with the clerk of master here at Davidson County like we normally do, or would you prefer?
It would be best if you send it to my office. I'll sign it and get it back to, review it and then get back for entry to the clerk's office.
All right, we'll do that. Your Honor.
That's the quickest way to get it done anyway.
Yes, ma'am.
All right, now, Mr. Greenberg, let's hear, and Mr. Meyer, I'll get an order now in fairly shortly.
Thank you.
Short order. All right. Now, Mr. Greenberg, tell me which motion you want to take up first.
Okay, I would like to first do the disqualification of the attorneys.
All right, and what basis do you think that you have for getting them disqualified?
They are both defendants. Well, let me open up the document. I'm not going to do this off the top of my head. This was filed at the beginning.
You read it?
Okay, you read it, but you didn't act on it. You know
Now, I'm
that
giving you an opportunity, to
this was
present it.
this was filed prior to you even be appointed. You know that both parties are defendants. There is a conflict of interest. You're aware of that. And you're trying to circumvent justice by having him dismissed, even though he's part of the action. And you're going to use the fact that you said there wasn't a claim stated against him as your means to say, oh, he was never really involved in the case. But ironically, when I sued the other judges, the first thing that came out was, oh, they're named parties. We've got to recuse ourselves because of a conflict of interest. So somehow the conflicts of interest for the judges warrants action at the time as their defendants, and I'm suing them. But for some special reason, this court has decided that even though I've named them as dependents and participants of this fraud, and the clear conflict of interest exists, that they are not to be disqualified. Now, I am going to open the document because there are other issues in there that are quite clear, and the fact that that motion was not heard prior to the dismissal is quite problematic, and you're subverting justice in the manner in which it was heard. But let's go to the complaint, whatever. Where's the docket?
This is your motion filed on October the 13th, correct, sir?
That was probably my last iteration, but I need to find out when it was originally filed. All right, so here. So on September 4th, I provided the court with the notice of disqualification of counsel John Mayer and Nicholas Bellamy.
Yeah.
Okay. And in that motion, I assert I filed a third-party complaint against them for the fraud they were trying to push through Robinson's court in this matter here. At that point, the conflict of interest arose. Unless you are willing to throw the case and not acknowledge a claim which was actually stated, and then somehow do that prior to hearing the motion for disqualification, right? Because as it stands now, he's still a named defendant in this case, even though you've issued an order for him to be dismissed. That's not a final order, and it'll probably go on appeal. And while it's on appeal, he is still a defendant. And my ex, Miss Gifford, is a defendant. So the conflicts of interest are still present. It's unclear how this court is going to undo the following. Under Tennessee Civil Procedure 14.0, a defending party may bring a third party into the lawsuit, defending party for a part of all the claims. There's other issues regarding his payment scheme that we'll get to, and I addressed in a subsequent motion that I would like to get on the record. Pursuant to rules of professional conduct, a lawyer shall not represent a client if the representation involves concurrent conflict of interest. A current conflict of interest exists if the representation of one client will be directly adverse to another client. And that is the case here.
What
They are-
other client, besides Ms. Gifford, is it adverse to?
I have alleged that Miss Gifford,
Which other client is it adverse to? Just give me a name.
so the mayor and Gifford have a conflict of interest. He's trying to protect himself while at the same time trying to protect her, but he's participating in the fraud. So,
All right.
no, there's
All right.
more, and I don't appreciate being cut off. That's you're
Well,
not.
Mr. Greenberg, I'm giving you great latitude, whether you realize it or not, in this
Well,
matter.
I am a pro se litigant. You're supposed to give me great latitude, and you're not supposed to hold that against me at every breath when it's convenient. But you
Mr.
are.
Greenberg, I'm not holding it against you.
You're trying to hurry me along, an individual with a disability.
Mr. Greenberg, please, let me speak. You are not presenting arguments that have any legal merit, but I'm allowing you to do that. Perhaps if I'm wrong, the Court of Appeals will grade my paper and tell me I'm wrong.
Well, that's
Now, Mr. Greenberg, if you've got anything else
I do.
to say in support of your request to disqualify Mr. Knapp, then give it to me now and fairly succinctly, please.
well. Now you're preying on my disability and my inability to provide it as succinctly as you would like, as if that's a criteria that must.
No, Mr. Greenberg, just please go ahead and give.
Yeah, I would like to not be hassled about my inability to present these facts. So by filing a third-party complaint against Myron for fraud and fraud upon the court and professional misconduct related to the underlying lawsuit, Greenberg has created a direct conflict of interest. Now they have divided loyalties between their own individual interests and the interests of their client Gifford in this action. In Clinard Blackwood, the Tennessee Supreme Court, an attorney cannot represent a client where he has interpleaded as a third-party defendant in the same underlying action. That is precisely what's happened here, and this court has allowed him to not be disqualified. Further, there is a conflict of interest in that he is attempting to perpetuate the alleged fraud in this court along with the other fraudster, Miss Gifford. Attorneys Mayer and Bellamy cannot continue to represent Gifford because of the direct conflict of interest caused by the third-party complaint alleging fraud upon the court against Bellamy by Grimmer in the same underlying lawsuit. Both Mayer and Bellamy have an obligation to withdraw as counsel for Gifford and advise her to seek independent representation to avoid the concurrent conflict of interest. That has not been addressed. That there is an ethical obligation that you're willing to overlook to help spread my mother's estate money around your ecosystem. Attorneys representing clients who perpetuate fraud upon the court through conspiracy, deprivation of rights, or sua sponte appointment of a guardian ad litem to an adult lose attorney-client privileges. Such fraud corrupts the judicial systems. Attorneys who knowingly fail to disclose their clients' fraud are complicit and exceed the scope of lawful representation. They can be held liable along with the clients for damages caused by the fraud upon the court, right? So, did Bellamy and what else together? Mayor disclose their client's fraud? No, not as far as I know. As officers of the court, the attorneys have an ethical duty to disclose and refuse to assist with frauds upon the court. That this is part of the conflict of interest. Why would they knowingly admit to the fraud Carla's perpetuated if they're trying to perpetuate the same thing? That's clear conflict. Failure to disclose the fraud, which had we heard the motions in the proper order of the sua sponte appointment, it would be well established and known to all in this court that fraud upon the court has indeed occurred. And I hope, it is my hope, that that is the next motion that is heard. That's why this was out of order. But the fact that they're both defendants should be enough that I'm suing them both, and they can't have conflicting interests. Now he's knowingly, Mayer and Bellamy are knowingly attempting to defraud the courts further, which exceeds the scope of lawful representation and makes them additional co-conspirators. And they did the same in Judge Robinson's court, which you are aware of because you had some meetings with the Chief Justice of the Tennessee Supreme Court, Holly Kirby, and Ann Martin, pro tempore presiding judge, in which you guys decided the quickest way to, in the interest of judicial economy, which doesn't really exist, that would be the easiest way to steal my money. So further, I have a right to sue the attorneys, the original fraudsters, under these circumstances.
All right. Mr. Greenberg, I think we're starting to sort of repeat the same thing. Your motion to disqualify Mr. Bellamy and Mr. Maher is overruled. They will continue in this case. Could I prevail upon you to prepare an order, sir, in this matter?
Yes, Your Honor.
Thank you. All right, what's your next motion?
Okay. So I would like to do the judicial notice next.
All right. All right, go ahead.
Well, I don't have it open. I gotta open it. And then once we establish that, then your orders for all that other stuff become void. But whatever. So respond to.
Your Honor, we ask you to refer to the date of whatever motion it is he's discussing.
I think there's actually, there's the one that I have in front of me, and I think that there might be another one, but it's dated October the 13th. I think there might have been a previous filing in September that touched upon the same thing. The notice of disqualification, I think. So if that might be helpful for you to be able to find the document. All right, Mr. Whitman, have you found your next motion?
I'm trying to find it on the docket, which the date is supposed to be. Let me do a control. I have one from December 8th, I think, but
Okay.
I don't know if that's the first iteration or what.
Well, let's hear what you got there.
All right, so judicial. Let's do that. No.
Mr. Greenberg, can you go ahead and
Yeah,
go
no,
into what-
I'm looking for something. I'm a little slow. I have a disability. That's okay, though. Unless it's not, you just let me know. Okay, it looks like on 11/29, plaintiff's notice of judicial notice, or 11/27.
Yeah, I see it.
Okay, let me open that one up. Kicked me out, gotta log back in. I'm gonna need to take a break after this short little exercise. What day date did I say? 11/27.
29 is what you told me.
All right. Just trying to.
Well, there's a 27 and a 29, so which, I don't know which one you,
Where did it go? Oh, right here. Notice of judicial. Let's click here and see if it gives me judicial notice PDF. Let's open this one up. Okay, yeah. This was filed on 11/27.
all right?
And I am asking the court to take judicial notice. Here, across the court. Essential facts and law regarding the unlawful sua sponte appointment of guardian ad litem by Judy Halifax in 13D00979. So the first item is the certified reporter transcript for June 6, 2017. Have we accepted that as fact?
Just go ahead and present your motion or whatever you want to say. I'll make a ruling on it. Go ahead.
Well, I would like to know that I don't need some blanket statement about what you want or what you don't. As you know, this is mandatory.
Mr. Greenberg, I'm going to give you an opportunity to say what you want to say about your request that I take judicial notice of certain things. You've got a bit of time to do that. So tell me what it is, and I'll listen, and then I'll make a ruling. So go ahead and present it, please.
Okay, so I need you to take fact or notice of the fact that transcript, that certified transcript exists. Two, that the sua sponte appointment of Gail Hickman as guardian ad litem occurred during the trial proceedings without prior notice or the opportunity to be heard.
All right, go ahead. What's the next thing you want me to take judicial notice of?
No findings. Yeah, there's another part of law that I need to do, but okay, we'll just do the facts first. There was no finding made on the record by Palafox Greenberg was incompetent before the court or of Hickman as required under California law. The applicable California statutes are written here and requires a notice motion with supporting declarations before an appointment of guardian ad litem in civil action, exhibits B through E. You looked through those, right?
Yes, I've looked at everything that you have filed. Mr. Greenberg, what else do you want me to take judicial notice of?
Daniel Greenberg was denied the right to present his case and evidence at trial. The trial proceedings were suspended after unlawful appointment of Gail Hickman as guardian ad litem over the objection of Daniel Greenberg. The foregoing facts of the transcript of procedural history of California case are appropriate judicial notice by this court under Rule 201. Furthermore, 202 allows this court to take judicial notice of California statutes and rules governing the appointment of a guardian ad litem. The above facts are relevant to the plaintiff's claims in this action, including violation of due process, conspiracy to improperly appoint a guardian ad litem by the California judicial defendants and third parties at all. Accordingly, plaintiff hereby requests judicial notice be taken of the above facts and law and the exhibits attached. So I don't know if you want to take care of the facts first or if you want to do the law.
You just tell me what the next thing is you want me to don't read to me what you filed, just briefly go through and iterate what you want me to take judicial notice of.
Okay.
I have read it and we'll look again, but is there anything that is not in your notice that you want to make me aware of, or you think I need to know that's not written in the notice that you filed?
There, somewhere there's all the case law that I need you to acknowledge as.
Well, I will look at the case law. You just, if you filed it, I certainly will look at it.
All right, let me
Read
see.
it.
Judicial notice. Open. Unfortunately, I think I'm skipping a whole big section, which. Okay, and as far as the, is that in here? So, under Rules 201, judicial notice of adjunctive facts and 202, judicial notice of law, as is judicial notice, is mandatory, and this can happen at any time during the proceeding. So, in addition to those facts that I would like the court to acknowledge, I need the court to acknowledge the facts. The facts of law in the case law attached. The Rankin v. Howard, Herms, Thomason v. Thomason, and all the other res judica.
Okay.
So the memorandum of, are you looking at the?
Go ahead and tell me what else you want me to take judicial notice of.
Well, there's a whole bunch of case law that.
I know, I'm aware of that.
No, so, do you want me to read each one of these to you?
No, I can read them. I can read what you've filed
So,
and have.
so courts are constituted by authority and cannot go beyond that power delegated to them.
That's not a fact.
No, yeah, we've already done the facts. Now
Okay.
we're doing the law.
Well, that we're going to do the facts, because I will apply the applicable law. I will decide what law applies and I will apply it. So are there any other facts?
Let me see. We're looking at. This one, December 8th. Is this the right key? Yeah. Okay. Appear to leave that one out. Let's see. The transcript. Which version are you looking at? Are you looking at the December 8th?
Well, I've got them all. Is there something else you want me to look at?
Well, I don't have, which ones do you have?
I've got them all, Mr. Greenberg.
Okay, so you have the 27th, you have
I've
December,
got everything that you have filed. I can't put my hand on it right now, perhaps, but I've got everything you filed. Let's move on. Are there any, I'm gonna ask you one more time. Is there any other fact that you have not already told me about that you want me to take judicial notice of?
yes.
Okay, what is the fact?
I was denied the right to present my case and evidence at trial.
And this is the California case you're talking about.
Right, it's a fact.
I think you already covered that, but
Okay. In addition to the facts of request.
all right. Anything further?
Okay.
All right, we're going to move on then. I'll read, if there's something else contained in your notice, I'll be sure to consider that, Mr. Greenberg. All right.
So are you going to make a ruling regarding those facts?
I will make a ruling, will give you a written order on that request to,
And so is that going to be granted? I mean, you took the time to give them the order right now. What do I have to wait for you to do some other magic?
Mr. Greenberg, I will put down a written order. Let's move on.
You're going to put down a written order
With
approving
my decision.
or denying the facts?
Mr. Greenberg, I'll put down a written order with my decision. Let's move on.
Okay.
All right. Now, I will tell you what I think we probably ought to take up. You filed several motions for default judgment, some of which are now moot.
Right, and that's
The
a
one against
problem.
The one against Tamar Armanac, I've already dismissed Ms. Armanac from the proceedings. You have filed one against Jennifer Posey and Robert Bullock. Did you get service of process on those defendants?
I did.
Okay. Did you file that with your motion?
Yes.
When was service of process obtained on Ms. Posey?
Oh,
Oh, I think
jeez.
we've already dealt with Ms. Posey, I think, actually.
No, there were people in default that you allowed to file a motion to dismiss.
Which is allowed, Mr. Greenberg. All right. What about Mr. Bullock? When did you get service of process on Mr. Bullock?
I'll have to find the documents.
Because I could not find in the record that you had gotten service of process on him, but maybe you did.
Well, let me point you to where it is in the docket, I guess.
Actually, it's Mr. Bullock is also, I believe, one that we've already dismissed from the case, is he not?
No.
Okay. I'm confusing him with someone else. Mr. Hickman, I guess, is what I'm concerned. All right.
And there's others. Let me look at the thing and then we can... The fact that there's not on the calendar is a little bit absurd. And I have to actually make the motion docket calendar in my head, which, as far as my disability goes, that's not the best thing in the world, but Why would I assume that?
All right, we'll give you an opportunity to do that. We won't take up that motion right now. What other
No,
motions do
no,
you
we-
have?
we're going to do all the motions to
Mr.
dismiss.
What other motion do you have besides this default motion against Mr. Bullock that you want to hear today?
Yeah, I'm looking. All these should be on the calendar. The docket calendar, but I'm having to reconstruct it on the fly. Okay, so on 10/27, there's a motion for default judgment against Bullock.
Okay, I know the motion is there, but I did not see where you had obtained service of process on it.
Okay, well, if you click on it, you can see that. Are you going to do that?
You just tell me when you got service of process.
02241 to defendant Robert Bullock. On the 30th day of August 23, I received the return receipt, which had been signed by the receptionist on 28th August 23. And attached is, in the filing, is the USPS certified mail receipt.
Okay, let me see if I can find Mr. Bullock again.
And additionally, there was the same default judgment for Robert Setch of DCSS. Where are those? I mean, okay. I'm not getting any of this stuff written down.
All right. All right. Just
Motion of default.
quickly, Mr. Greenberg, besides motions for default judgment, are there any other motions pending that we have
Yes.
not addressed?
Yes.
What other motions besides the ones having to do with default judgments?
All the ones for summary judgment.
Okay, some of those, I believe, deal with people who have been dismissed from the lawsuit. Is that correct?
Yes, I would imagine, and that's why it's concerning that my motion was not heard prior to theirs.
Okay. Are there any defendants against whom you have filed a motion for summary judgment that were not dismissed already?
Hold on.
All right. Ladies and gentlemen, let's take about a 10-minute break right
Yeah.
now. I'll let Mr. Greenberg tell me which summary judgment motions are still pending because the defendants have not been dismissed. And I'm going to take a quick moment to look at some of the service process issues that we have.
All right, sounds
Let's
good.
take about 10 minutes, and we'll come back in 10 minutes and resume. How about that? Thank you.
That's.
embedded in other pleading or something.
I don't know.
It's like, there's a new complaint embedded inside this as well. That's right, every attorney you hire would have to review the subject to represent you. Sure, that'd be great to have. Yeah, the defense bar, insurance defense bar would love that. Your payments fees are get tendencies, right? You got an interest in case you should be reviewed.
Give it like 2 hours and see what happens. All right, I gotta go back.
Right, she ordered on that. She already issued. The motion is called for. I didn't hear several motion. I thought this is a judge review, so it's and.
I say something that's caustic to the judge, and then now you're in
You
contempt.
got a motion, you got it on these, you really ask the jury to really get to work.
How does that work with the police officer? Don't you have freedom of expression to tell the police officer to hit the high road? But you can't tell that to a judge. They're both public servants.
I understand why, police can burden side of
Public servants in this
the
room.
laws, not a big question.
I think I'm missing something. All right, so the default judgments, what else did I want to have heard? Let's go back from this way.
Judge state the original force of the law in the state of California. Judge Roberts. You didn't have to be there. You didn't.
He is. All rise.
So, where's the recusal?
Court is now back in session. May be seated.
All right. Mr. Greenberg, let me tell you what I'm going to do with regard to your motions for default judgment. Can you hear me okay? Mr. Greenberg? Can you hear me now, Mr. Greenberg? There we go. Can you
Yeah.
hear me, sir?
Yes, I can hear you.
All right. You have filed several motions to dismiss. I've just gone back and reviewed that. You've also filed several motions for summary judgment. On the motions for default judgment, there are a number of those defendants who have already been dismissed from the lawsuit. Some have not. Those that have not, I need to review your service of process and the return of service of process. And it's a very simple matter. Either they were properly served and have not answered, or they weren't properly served.
Correct. And we can't
So
make
I'll
that.
look at that.
Why can't you look at that right now? It's not going to
Well, it's
change.
I realize that, but I want to look at it carefully and make sure that I'm not making a mistake. So I'm going to do that. Also, likewise, on the motions for summary judgment, several of those defendants have been dismissed already.
Right.
So those we would not be dealing with. On the ones that have, I will probably, if those are still valid and pending, we'll schedule a quick hearing on those for those particular defendants. I just want to make sure we're doing it correctly, Mr. Greenberg. I don't want to rush through it. So that I've given it, that I've really taken a look at everything you filed and given it appropriate attention.
Okay, so in a
That's what I'm
cursory
gonna do
list,
on that.
I have default judgments for Tamara Armanac, which you apparently dismissed, even though she was in default. Jennifer Posey, who I'm not sure why she was dismissed. She defaulted. She didn't even.
But just give me the list of the people so I can go back and review it, okay?
Okay, Posey, Leah T. Wilson,
All right.
Binkley, which you just created a final
He's
order for.
dismissed. Yes.
California State
There was
Bar.
All right.
Keith McCorney.
Could you spell that? I'm sorry, I couldn't
Yeah, I
understand
think
what you're
it's
saying.
Keith Keith McCorney, MCHORNEY.
All right.
Robert Sedge,
Yes.
Cheryl Feiner, and Orange
Alright.
County Department of Child Support Services. And then whoever else I filed one against that I missed.
So this is just the last names of these defendants you think that we still have, that have not been dismissed and have default judgments pending. Mr. Sesh, S-E-C-H, Ms. Posey,
Yeah.
Wilson, California State Bar, Mr. McCorney,
McCormick, yeah, McCorney, that's right, yeah.
Finer, and the Orange County Department of Child Support. Is that correct, or Child
Right.
Services, one of them?
Yeah.
Okay, all right.
And then
you
also,
do
Marjorie Haynes, she never accepted service. That was Carla's previous attorney. And so I have yet to actually have her served. So got to work on
No
that.
service, okay. All right, no service on her, all right. All right, so those are the ones I need to examine the service of process and the return on, and see whether, when they were served and the 30 days is run on them filing an answer and that sort of thing, okay?
Okay.
And I will do that. And I honestly, if they have been properly served and you serve the motion on them, then it really is not anything that requires proof. It should be of record. You understand
Right.
what I'm saying? Okay. So now with your motions for summary judgment, who have you filed summary judgment motions against that has not yet been dismissed from the lawsuit, or is not dismissed from the lawsuit?
It should be the same
that.
parties.
Same parties, okay. All right, so I can double check that then and see if they have responded in any way to that. I don't have any responses that I'm aware of. All right, besides your motions for summary judgment and your motions for default judgment, we've already discussed your request that I take judicial notice of certain facts in this case. Are there other pending motions other than those that I have just mentioned that need my
Yes.
attention? I just want to make sure I've not forgotten anything or left anything out that you have filed.
Okay, I'm going through the list now to the best of my ability
Okay.
without it being written out.
All right,
I had filed a motion for a new divorce trial by jury.
okay.
Let's see.
When was that filed?
That was on 131,
All right,
but it won't make sense unless we hear the sua sponte appointment of the guardian ad litem, because
Okay.
that's the bulk of the fraud that would warrant the new trial. But Mr. Mayor's assertion that I could send,
Well, let's just see. So you've got a motion for a new divorce pending,
yes.
and
And I'm looking.
anything that I have missed, I'll be honest with you, I haven't had a chance to read that, so, but we're not taking that up today, so. we
And
need to
then,
deal with matters.
depending on whether or not you dismiss yourself from the other case, then I might need to have you dismissed from this case because you can't do both. I don't know how you want to address that.
Tell me which other case you're talking about. The other one that,
231069 Part 3. And then I'm going to need
23069.
Part 3.
Part 3, all right.
And then,
I think I know which.
yeah,
what
I mean,
allegations
that
are.
was when
I
they
just
seen,
want to make sure we were all on the same page.
that was in the Holly Kirby order in which you were assigned both of my cases, but obviously your participation in this one precludes you from having any participation in the other one, despite their assertion that a judicial economy would allow such a thing. But that's obviously a conflict of interest. So,
What other motions? Let's just make sure we get that I know exactly what motions are still pending that need attention. And if they need another hearing, we certainly we'll schedule that.
I'm pretty sure we need to have, I think in this case, I would like to request that the court provide me with the rules of scheduling motions.
Those are local rules and the rules of civil procedure, which should be available to you.
Okay. But
all you gotta do is-
I've run into the problem where I've filed these motions for default, and then you've dismissed them prior to them.
I think I've dealt with any motions to default. I have dismissed people on their motion requesting a dismissal, but that is appropriate. So go ahead. Just tell me again what motions, have we covered the motions for default judgment, the motion for summary judgment, and your motion for a new divorce trial are still pending, correct?
And the recusal.
I put down an order on the recusal yesterday. I did not recuse myself.
Okay. Do you plan on recusing yourself from the other case?
I don't know that I have gotten anything requesting me to recuse myself in the other case.
But you know that you're assigned to another case with me involved, right? So
I have gotten I just told you, I haven't had, there's nothing pending requesting me to recuse myself in the other case. I have not at this time, and don't plan to, Mr. Greenberg, so.
Oh,
if
that's
you
a
want to
problem.
file something- Well, if you think it's a problem, please file whatever you think is appropriate.
well, I did in this previous iteration of the recusal request, and it outlined that very particular issue. And in fact, in the letter that I wrote to you and the Supreme Court Justice, I alerted you.
Mr. Greenberg, what other motions are still pending?
I guess the judicial notice of law, facts of law.
Okay. All right, I kind of lumped that all together. Your request that I take judicial notice of certain things, and facts and law, I understand that that's all of those you want me to rule on.
And so how's that going to work? You're going to issue an order saying that Rankin v. Howard is...
I'm going to issue an order and then on what I think is appropriate. And if you take issue with that, there's a method for you to deal with that. Is there any other motions? That's all I need to know, Mr. Greenberg. Any other motions that you have not told me about already?
Let me go through the list again.
Motions for default, judgment, summary judgment.
I'm looking.
Request I take judicial notice, motion for a new divorce trial. That's all I saw, Mr. Greenberg, I will tell you that, but I could have maybe missed something in looking through the list.
Okay.
While Mr. Greenberg is looking through his list, I will be getting you an order on your motion. You are preparing an order on your motion. You are likewise, so I think we have got that covered, and then I will prepare the orders, obviously, on the other motions that Mr. Greenberg has raised. And we won't be taking up any other motions today, ladies and gentlemen. I don't want to keep you waiting if you've got other places to be. Mr. Greenberg, if I can need another hearing in order to make a ruling on your motions, we will certainly set another hearing. It may be that they're self-evident when I read your motions, and I won't need another hearing. I may be able to rule on them without another hearing. It may be that you put everything in your motion that I need to consider, but I will take a look at it, okay?
Okay, well, there's one other issue regarding my motion that I need to have heard.
What is that?
I'm trying to find it.
Is it in the motion or it is another motion?
It's another motion. Yeah, it's.
Well, I tell you what, Mr. Greenberg, when you find that other motion that you want me to take a look at, if you would just alert the clerk's office as to what motion that is, and I'll have them make sure, if I don't already have a copy of it, they'll let me know and I can print a copy and take a look at it, okay?
Okay.
And if it's something, again, that if I take a look at it, I think, oh, I need to hear what Mr. Greenberg has to say about this, and whoever else is involved, I'll certainly schedule a hearing on it, give you that opportunity, okay?
Okay, I guess. I'm
All
being
right.
hurried through this. And can I make a request that for the next set of hearings that we have, that a motion docket be created? Because this is taxing on me. Do I have to make a ADA request to have this done? I mean, it's obviously a standard operating procedure throughout the rest of the Tennessee area judiciary to have such a thing. But for whatever reason, you felt it's appropriate to discriminate against me on my disability, based on my disability, to not have this available. So will you be providing? And then I got a message yesterday from the clerk.
I will not be providing that to you.
You will not?
I will not be providing that to you.
Well, who is supposed to?
Well, Mr. Greenberg, if you will read the local rules of civil procedure, and you will speak with the clerk's office, I think that they can certainly enlighten you on how you can get a copy of everything. It's pretty clear in my orders that I'm hearing that the motions that I will be hearing are motions that were set on a certain file before a certain time, or motions to dismiss that were filed. I'm fairly clear in my orders about what we're going to hear that day. So.
Right, but that doesn't explain.
You will be provided everything that the rules of court and the law requires us to do.
Okay, so when.
So that, Mr. Greenberg, We are finished today. This court is adjourned. Thank you.
All rise.
What a waste of time. Yeah, that went as well as possible.